Sachs versus Sachs.
May it please the Court. I'm Clifton Gorenflo. I appear on behalf of the appellant Linda Marie Sachs, seated to my left. I would like to reserve 5 minutes for rebuttal, if I may.
Okay.
This case is a direct appeal of a final judgment of dissolution of marriage and multiple pretrial orders. I'm sorry, sir.
Counsel, we've read the briefs and we're familiar with the facts in the case. Tell us why you think Judge Breeze's order is in error on this case.
Well, it's surreal to be standing here 28 years after Kanakaris, 23 years after Nichols, representing a woman who was compelled to go to trial literally penniless without an attorney, while her husband, who, according to the record, had income in excess of $55,000 a month, had 2 attorneys. And
wasn't there a prenup agreement, though, in this case that was upheld?
Absolutely, Your Honor. That's one of the third of the, I would say, the 3 core issues we're here to talk about today is the prenup. Yes, the prenuptial agreement provided that neither party would pay attorney's fees, and of course the case law is crystal clear that that does not apply during the pendency of a trial, and the court must award attorney's fees to a spouse who has less income and the inability to provide representation of her own. In fact, the very initial hearing in this case, the first temporary relief hearing, the trial court found that David Sachs had the ability to pay, Linda Sachs had the need for attorney's fees, and awarded $35,000 in attorney's fees. 2 years later, her then attorney, Garrett Briggs, filed a motion for attorney's fees and received a partial award of attorney's fees for his prior actions, but not for the ability to go forward to trial. And the court failed to award at that time attorney's fees to proceed to trial. When Mr. Briggs withdrew and she proceeded to trial on her own, asking for representation multiple times between his withdrawal and the trial, she filed multiple motions for a continuance, multiple motions for temporary attorney's fees that were summarily denied by Judge Breeze at each instance.
Wasn't there already an amount of attorney's fees that had been paid by the husband to the former wife?
Yes, Your Honor. There's an amount awarded to be paid directly.
What was that amount?
$82,000, paid directly to the prior attorney who at that point had withdrawn. Not payable to her. She had no ability at that point to engage new counsel, to retain new counsel. She stated in multiple motions that she had spoken to several local attorneys. Each one had various retainers, and she did not have the ability to engage new counsel. So the record is clear that at least from that point, November of 2006 forward, she had an inability, a desperate inability to retain counsel that her husband at the time did not have. The other major issue that...
Before you move off that issue, the thing that was interesting to me was this whole business about why she didn't have counsel anymore. And I'm not sure I understand the chronology of that time frame right around when Garrett Briggs left the case. So if you would kind of walk me through that.
Certainly, yeah.
And this debate about the termination versus withdrawal.
The record is clear that in June of 2006, Attorney Briggs filed a charging lien against Ms. Sachs and caused a final judgment to be recorded against her at that time for $25,000 in excess of what he had billed to date. I think it was $97,000 for the stipulated final judgment of charging lien he had her sign off on and had filed in June of 2006. I would clearly submit the record is clear at that point that he had stopped representing her, was representing himself to get paid. At his motion for attorney's fees, where he was awarded the $82,000 paid directly to him.
So the charging lien was for $97,000. He got $82,000.
He got $82,000. He had requested an additional $25,000 to go forward from that point to trial. $82,000 in prior fees, $25,000 in expected trial fees. Judge Breeze denied his motion for trial attorney's fees. He then withdraws.
Well, did he withdraw or did she terminate him?
He filed a motion to withdraw that was granted by the court. He attached to that motion a termination document that he had prepared in his office. The record's not clear on who and when and where it was prepared. It's not handwritten by Ms. Sachs. Every document she ever filed after that was handwritten by her. It's on the same style, case font, everything as the motion to withdraw. And
the trial court considered that to be important, did he not? That she had terminated him.
Subsequent to that, at the hearings in denying her motions to continue because of the social investigation was incomplete and her motions to appoint or to get money to hire a new substantive attorney, yes, argument was made of the Ryan case and arguing that since she put herself in this position, if she fired her attorneys, you can't come in at the last minute, the day before trial, with a new attorney requesting a continuance or having fired successive attorneys and come in and say, Judge, I need more time, I need an attorney, I need more money. That's simply not the facts of this case. You've got one attorney representing her for 2 years through the core of this litigation, awarding his attorney's fees to date, not getting trial attorney's fees, and withdrawing. So I think it's semantics whether she discharged him or he discharged her. The attorney-client relationship broke down at that point. He did not proceed to trial. She had no representation to proceed to trial, and she desperately needed it and desperately requested it.
Did the trial judge enter a speaking order on the denial of the $25,000 going forward?
It's included in his written order on the motion for attorney's fees that Garrett Briggs filed. He specifically denies it there.
Did he say why?
He subsequently says that he wanted a detailed summary of what would be billed in the future, is record. In their answer brief, the husband makes light of he was denying future fees under Rosen, or he was concerned with the vexatious litigation of the case at that point, and that's simply not supported by the record. They raised Rosen as an issue in the very first temporary relief hearing when she was seeking sole custody. They didn't prevail on that. During this attorney fee hearing, the whole thing was, Judge, you shouldn't even give him the $82,000. It's been vexatious, it's been litigious. And the court made a specific finding that all the litigation about the prenuptial agreement, while highly contested, was valid defense and was valid litigation, and denied their request to not award fees based on Rosen. Yes, he made a reservation that I'll reconsider it at the final judgment if we need to.
I'll reconsider trial attorney's fees.
No, he'll reconsider the Rosen issue of denying fees or granting fees or shifting fees because of Rosen, but has never denied fees or reduced fees because of Rosen or because of any vexatious litigation or threats to continue.
Okay, so he denies the fees going forward when he enters this order. Doesn't say why, but then you started to say that subsequently he said something about wanting a detailed projection of what the fee is.
He references that in the paragraph where he's talking about the $25,000 for trial attorney's fees, of wanting a detailed explanation of what those are for.
This is in the order.
In the order. And then in subsequent hearings where they're addressing the issue, I believe in one of the transcripts he specifically says, I reference what I need to award temporary trial attorney's fees.
I didn't understand that. Say that again.
I believe in one of the subsequent transcripts he referenced, again, that he had stated what he needs. He denied her subsequent motions for temporary attorney's fees on what I set forth in the order previously.
Counsel, let me refresh your recollection on what the judge actually said in his order, and I'll read it to you. It's paragraph 13 on attorney's fees. The court has previously ordered the husband to pay the wife's attorney the sum of $82,000. If the husband files a proper motion, the court will consider whether any part of this motion he paid on behalf of the wife or additional fees he incurred as a result of the wife's action should be repaid to the husband based on the criteria of Rosen versus Rosen. That's what the judge did in his judgment.
Correct, and never did. He never denied fees based on Rosen. He simply reserved that I might consider that in the future. He granted the attorney's fees. The previous judge granted attorney's fees based on the...
Has any motion been filed to have him consider fees?
It was not raised at the trial.
Has any motion been filed since the entry of this judgment that would raise that issue and have the judge make that determination?
I believe so. And nothing's been set for hearing or nothing has been determined by the court. There are post-judgment issues concerning the attorney's fees, the payment of the attorney's fees, the disposition of marital property.
That really isn't an issue in this appeal then, is it?
Sir?
So that really isn't an issue in the appeal then, is it?
Right. The trial judge never denied fees based upon Rosen. It's simply an argument that the husband is making in his briefs, trying to infer that that's why he didn't grant temporary attorney's fees in order for Ms. Sachs to proceed to trial represented with counsel. But if you have any questions, I'll stay with attorney's fees. But I think much more important is the issue of the social investigation that was incomplete and the request for attorney's fees, the request for a continuance to have Dr. Day finish that social investigation. Almost as early as November, when the trial withdrew, the case was not set for trial when the attorney withdrew. Immediately afterwards, it's set on a case management and is subsequently set for trial. Linda files a pro se motion asking for attorney's fees, asking for a continuance of the case management, asking for a continuance of the case management to allow Dr. Day to finish the court-ordered social investigation that was pending. Everybody knew she was working on it. At the pretrial conference in January, at a hearing in February, all the parties are talking about it, the judge is aware of it. We have multiple motions to continue to allow Dr. Day to finish the social investigation and for the parties to have time to review it and rebut it. Since Kern, every district court has held that when a trial court denies a party a motion to continue to allow a social investigation to be completed or to have a meaningful review and opportunity to rebut it, denies that party due process. So irrespective of whether the court should have granted her attorney's fees or continues for attorney's fees, we have an absolute clear denial of due process on the issue of the social investigation is not complete. Everybody's waiting for it. Dr. Day apparently finishes it days before trial, disperses it, and then it's an issue at trial. The judge admits it into evidence, heavily relies on it, and follows it verbatim in his final judgment. The case law is clear on that. The argument raised on appeal...
Isn't our standard to review, though, abuse of discretion on the continuance issue?
On the continuance issue in a normal situation, yes. And in the case of Ryan, which they heavily relied on at trial and on appeal, yes. Where you don't have any of those other factors involved, sure. Kern is crystal clear. It is a denial of fundamental due process. A trial court doesn't have the discretion to deny a party due process.
Well, certainly in our determination of whether there's an abuse of discretion, we look at that. But, I mean, it's still the standard of review is abuse of discretion, is it not?
If the trial court applies the correct law, yes. And if it's within the area...
In order to determine whether or not there was an abuse of discretion, we have to conclude that no reasonable circuit judge would arrive at that same decision that Judge Breeze made of denying the continuance.
No, Your Honor. If absent the issues of the social investigation and the attorney's fees, yes. With the pending social investigation, it's irrelevant. It's outside of his discretion. The Supreme Court has mandated that...
How has she been on the issue of attorney's fees? She hadn't been prejudiced by that because he says in his judgment that she can file a motion for that later on. So how is there any prejudice there?
She requested 5 separate times the ability to retain counsel during the trial. Every time she got an opportunity to, she objected to the trial and requested the assistance of counsel. She desperately wanted counsel. This isn't a case like Anderson that they cite on appeal where the pro se party says, oh, I can do this on my own. I don't need an attorney. She wanted an attorney at every turn. She didn't have the financial ability to hire an attorney. He had stopped paying all the support that the court had awarded months before. There were pending motions to compel, motions for contempt on the support issues. There's the denial of trial attorney's fees. She had no choice. And it's amazing that this far after Nichols, we're having this conversation of a woman going to trial without representation when she wants it, when he has the ability to pay for it, and she desperately has that need.
Is there any indication that anybody knew about Dr. Day's change in recommendation about custody before the hearing?
Nothing in the record, Your Honor. it seems clear, because just of the timing of it, I imagine that the husband's counsel was in constant contact with her, the court was in contact with her. I'm speculating, it's set for trial, we need the report. No indication of the 180-degree change at all in the record. Your Honor, if I may, I'd reserve the remainder 5 minutes for rebuttal.
Good morning, Your Honor. I'm Leonard Ross here on behalf of the appellee. I'm co-counsel with Mr. Rose, so if there's any questions dealing with point 3 on the initial brief that was not raised in the argument initially by Mr. Gornflow, Mr. Rose would address them. Your Honors, initially, the question that you asked with respect to the reports, if I may, obviously, to preserve an issue for appellate review, one must make an objection. It must be the same legal grounds that you raise on appeal that you stated in the trial court. What's crystal clear here is that when we came to trial, there was no objection made by the wife in any way whatsoever concerning any of the reports. And Judge Breeze, when you read over the record, bent over backwards to ask anything. Is there any objection you have? None whatsoever. So when the courts asked, was there any indication whatsoever, and Judge Griffin, I know you asked that, any indication that they knew what was going on with respect to anything, that any writings of Dr. J or Ms. Stampa? Yes, there's every indication. Every indication is the fact that initially, way back in January, at the January hearing, in the transcript of the hearing, it states Dr. Day found nothing happened. In addition to that, there was a pleading that we filed wherein we attached a copy of Dr. Day's latest writing. And Dr. Day's latest writing, Judge Breeze gave that to the parties to read even before the trial started. And is there any comment? Nothing whatsoever. No objection at trial. We had Dr. Day subpoenaed to come to court that day. We had Judy Stampa subpoenaed to come to court that day. We canceled that once the trial was over because there's no objection. We provide the writings, no objection. And not even a legal objection is what I'm pointing to. Any indication of surprise. There was no surprise. All of the parties had been in contact with Dr. Day and Judy Stampa and every other counselor. Everybody knew what was going on for months with respect to this. In addition to that, there was a closing argument that the wife made. During her closing argument, not a word about an objection. Then, when the court issued its verbal ruling, which was rather lengthy, not a word about an objection or surprise in any way whatsoever. Then, the wife filed an objection to the proposed final judgment. And there was a writing. Nothing in any way whatsoever that there was any surprise. None whatsoever. So, Your Honors, there is no surprise whatsoever. The key with respect to the case itself as to the wife's actions is controlled by the fact that this had 2 days of trial set. We had March 9th and March 12th. March 9th, we used up a fraction of the time. If the wife wanted to call witnesses, if the wife wanted to say, look, I'd like to cross-examine, that's fine. Or, you know, Judge, we have a whole other day set for trial. Everybody knew there were 2 days set for trial. I'll call witnesses for then. Nothing. The wife, in fact, besides the dilatory practices that the court referenced throughout many orders, besides the false allegations that had been found by the court, besides the lies that had been found by the court, the wife did nothing, did not refuse, did not participate. And this court, in its opinion with respect to the Ryan case, specifically said you cannot simply say, I'm not going to participate. This case is rather stronger than that case, because in this case, the wife didn't just not participate, but she then made a closing argument, a rather lengthy closing argument. So in part she participated, but for the rest of the trial she did not. If you look at all of the cases that were cited by Mr. Gornflow also, dealing with any reports or writings whatsoever, each one of those cases, there is an objection. Every single one of them. Or the court didn't let a party cross-examine the preparer of a report. Every other one, there was an objection.
But didn't she request to have a continuance because Dr. Day hadn't finished her report?
She did. And that was one of the things that she said in there. And in fact, what we stated way back in January was Dr. Day found nothing happened. So that was in there. That was in there way back in January. She knew this, we knew this. And Your Honor, what's so indicative of that fact is the fact that on every opportunity when the writing is presented, I mean, even not just presented, the court, like I said, bent over backwards and said, read this, look it over. Not a word about surprise. Not an objection, nothing. I mean, if you don't object, and you don't have to say it in legal terms. I mean, I understand if you don't always say it in precise legal terms under the rules of evidence, but at least you stand up and you say, wow, I don't know about this. I don't know anything about this. But if you don't say that, it's obviously waived, number one, and two, it's obvious that you know about it. There's no surprise. With respect to the attorney's fees, Your Honor, as you pointed out, where the court indicated, $35,000 in attorney's fees initially, over $82,000 later. The wife had 6 attorneys in this matter. She had Dawn Nichols to start with. In the initial petition for dissolution of marriage, Dawn Nichols asked for shared parental responsibility, and the wife swore to the petition. She then later fired Dawn Nichols. She admitted that the allegations that she was making, these allegations that everybody has found unfounded after unfounded after unfounded, but she persists, as Judge Breeze pointed out. She admitted that those things she knew about before she said shared parental responsibility, that she swore to. She then fired Dawn Nichols. She then hired Mr. and Mrs. Briggs. She had Mr. and Mrs. Briggs do all this work. She then fired Mr. and Mrs. Briggs. And Mr. Gornflow wants to kind of ease over the fact as to whether or not she fired Mr. and Mrs. Briggs. But it's plain, and in writing signed by her. She fired them. And she complains about them. Just like she complained about Dawn Nichols, she then complains about them. And it's not that they just withdrew for lack of money. She specifically said that she complained about them. They didn't do this, they didn't do that. So she fired them. Then she has a Mr. Tischler and a Mr. Perillo from the Melbourne area. She later complained about them. And in addition to that, she had Mr. Levin on a separate case from Longwood. In this case, as we put in evidence, the fact that the wife in her interrogatory said, you know, she needed money for manicures, pedicures, facial massages. She missed one of the hearings that we pointed out in the record because she was on a Caribbean cruise. But most significantly, Your Honors, as the court found, she threatened specifically to drag this case on. I mean, we were like 4 years into this. And as Judge Monaco has said in one of the cases, litigation has to finally come to an end. She continued to make unfounded allegation after unfounded allegation and nuclear options, calling everybody in. If one party said, no, this didn't happen, another one, and another one. And, most importantly, I think, her credibility was clearly lacking, and the court found that over and over and over again. Thank you, Your Honor.
Your Honor, the error here occurred when the trial court denied the motion to continue to allow time for Dr. Day to complete her job, irrespective of what happened during the trial itself. The cases following Kern, every district court has held that when a trial court denies a motion to continue to allow the investigation to be completed, the report to be reviewed, he denies the parties fundamental due process. So the error occurred well before March 9th when the trial started.
Counsel, you said that the investigation needs to be completed. It was completed, wasn't it? She was just objecting because she was surprised at the result.
No, Your Honor. Dr. Day filed her report on the 7th. The trial went to...
But wasn't that the end of the investigation, though? With the filing of the report?
2 days before trial.
But it was
months
final.
after she had requested the continuance to allow it to be completed. Months after she had requested the...
I'm confused in my mind as to what needed to be completed after the report was filed. What needed to be completed?
Nothing needed to be completed after March 7th. The motions to continue were in January and February, requesting...
What is the chronology of Dr. Day's report? There was an initial report, and then there was the so-called update, right?
Correct, Your Honor. She was appointed back in, I believe, 2004.
Yeah.
She begins her initial investigation. She meets with the parties. She does her preliminary report. That's filed, incidentally not admitted into evidence in the trial. Only the updated supplement was. And then the parties continue, the allegations continue, and she is, by everyone's knowledge, supplementing her report, working on updating the report for trial. She has, I believe, Dr. Greco do a psychosexual evaluation on David Sachs. That report is never submitted to anyone or filed. I believe it was completed, and Dr. Day evaluated it because she references it in her final report. Again, that's, I believe, faxed around on March 7th, 2 days before the trial. So if there's a suggestion that everyone knew Dr. Day was updating it, absolutely. That's why Linda Sachs filed the request for a continuance, to allow it to be completed, to allow opportunity to review it and to rebut it. And you've got to couple this with the fact...
You still haven't answered my question. What needed to be completed? Obviously...
The report. In January, when she moved to continue, the report was not done. In February, when she moved to continue, the report was not written.
But when you went to trial, the report was finished, was it not?
Correct, Your Honor.
So there was nothing to be completed?
Nothing to be completed on the day of trial, no, Your Honor.
Okay.
Did you have the report? Did you have the report?
I didn't represent her in the trial court, and I believe...
Was the report, did she have the report?
At trial, yes, Your Honor.
Okay.
But Kern, in the cases
Was
following...
Dr. Day or any of these other witnesses subpoenaed to be there so she could cross-examination?
None of them appeared, none of them testified. And again, that's one of the fundamental issues when the Supreme Court was dealing with Kern and the whole ability to allow all this hearsay in to custody decisions in the first place. They said it is contemplated that the preparer of the report would be at trial and would testify. It is contemplated that they would be cross-examined, that the report would be fully vetted well prior to the trial, not delivered to the parties 2 days before trial, a complete 180 of anything that she said in the past, and the court simply admitted the hearsay document into evidence and rely heavily upon it. So we've heard a lot about she didn't say the magic words objection hearsay during the trial. What she did say is, I object to not being represented by an attorney. I want temporary attorney's fees. I want to be represented by counsel. I request a continuance so I can be represented by a counsel. I request a continuance. She didn't at that point say, so I can review the report. She had on 3 previous occasions, requested the continuance to get the report completed, to review the report, and to be able to come to trial with an attorney if she got attorney's fees, perhaps by herself with the report, with the ability to read the report, understand the report, and rebut the report. So the error occurred in January and February and March, not necessarily during the trial itself. This trial never should have occurred under those facts and circumstances. The temporary attorney's fees, we keep coming back to whether she fired Garrett Briggs or he withdrew, and I don't think that's material because you have the situation at least in November of 2007 where the case is not set for trial, and she has no ability to hire an attorney. He's cut off support. He's not providing her the court-ordered support. She has no award of attorney's fees, and what award she did get, she didn't get. It went directly to her prior attorney. So she received not a dime of support from the court. She didn't receive a dime of support from her husband at that time and had no ability to hire an attorney. That's classic Nichols. That's classic what the Supreme Court has said over and over again we're not going to allow. It's a fundamental due process violation. Thank you.
Thank you, counsel.